Why don't you put us in a breakout room?
Okay. Let's just picking the date first. Friday, February 5th at 11 o'clock.
Can I just
Okay.
confirm if that works for our victim?
Yes. So if there's a victim on the case that would like to be heard on the scheduling for February 5th, 11 o'clock, now would be the time to say something.
Yeah, that works for me.
Okay, thank you.
Thank you.
And this Friday's date would be taken off the calendar.
All right.
And then I'll put Attorney Reitz into a breakout room with his client.
Sure.
And now we're off the record on Mr. Sweat's case. Griffin Kulo.
That's me, Your Honor.
Anybody here named Griffin Kulo?
Your Honor, I'm about 99% sure that he's in the Winnebago County Jail.
Let's call the case then. This is Brown County case number 20 CM 1039, State of Wisconsin versus Griffin M. Kulo. The state is here by Assistant District Attorney Jessica Petrus. Attorney Shannon Beal is here. Mr. Kulo does not appear. We're doing the hearing by video conference because of the global, national, and local public health emergency. Mr. Kulo does not appear on the video conference, and he also does not appear in the courtroom. There's no one in the courtroom gallery. Attorney Veal.
Thank you, Your Honor. Your Honor, I was checking CCAP, and I apologize, I can't really bounce between my screen and CCAP, but if you look him up, it should show that like a couple of days ago, late last week, he was arrested and charged with another case. He already has one up in Outagamie County, but he just got charged in Winnebago. Now, it looks like he was given a signature bond, but I know he's on probation, and he was on a hold when he was in Outagamie County Jail for that case. So that's why I tried to verify with the Winnebago County Jail, but I can't get through to somebody. But I would be shocked if somebody could be arrested and charged with 2 different felonies in 2 different counties and not be on a PO hold. So that's where I think he is. This case is just a misdemeanor. I would ask that it not a warrant not issue. We just set it over. In addition, this case will be going to John Herman in our office. I'll be transferring off the case, but again, this case was always just going to kind of ride as sort of second priority to his other more pressing matters.
And any comment from the state?
I would just note, I did search VineLink quick, and according to VineLink, he is still in the Winnebago County Jail.
Okay, thank you. For another court date, how about Tuesday, March 9th at 2:30?
Thank you. What time?
2:30.
Thank you.
And then bond continues, and that's all for today. Thank you.
Thank you.
And then we'll wait for Mr. Sweat and Attorney Reitz to come back. Attorney Reitz has the only other case. So we have to wait for him either way.
Sounds good. Thank you.
Okay, I think I gotta pull them out of there. Let me see if I can send a message first. Did you get a message when I typed a message, ADA Petrus?
I did.
Okay, I don't know if that goes to the individuals in the break room, but in the breakout room, we'll give them a couple minutes though if they received it.
Sounds good. I think it might go to them, but I'm not positive.
It says message to all, so I assume it did.
Yeah.
Two.
Okay, we'll see. He's back now. We're back on the record on Mr. Sweat's case. All the parties are present again. Attorney Reitz, is there anything else to take up for today's purposes?
Just for the record, what my client wanted to speak to, which has been an issue, and I just want to put it on the record so the DAs are aware of it. I'm seeking access to the alleged victim's laptop. And I don't know if I'm going to proceed via subpoena, if the state would acquire that, but my client asserts there's exculpatory evidence on the laptop, on the juvenile's laptop. I can have discussions with the DA regarding that issue, and we can address it next time. And there's also an issue regarding getting a forensics person in to evaluate the cell phone, which is in evidence. And those are the things he wanted to speak to you about. I have now done so. The one other hiccup is that in order to do those things, I need to get PD approval for the expense of any forensics that might be available. So that's what he wanted to speak to.
Okay. So Attorney Reitz is going to contact the DA's office, you said about that before you file anything with the court?
I've already done that, but I'll follow it up again.
Okay. Well, just to let everybody know, I do have this marked as a number 1 for Wednesday, February 24th, just so that we keep that in mind.
And my client's aware of that. He actually, and if you recall, that's just outside the speedy trial. It's like a day or two after the speedy trial, and I couldn't do that. But now my client's saying if there's progress, he would consider waiving that. And as a practical matter, I've got the number 2, so which is the next case. So there's a good chance I'm going to be in your courtroom on that day.
Very good.
Unless
Okay.
I have a
ADA,
question.
did you want to ask the court in the public hearing, or would you like to ask the prosecutor first? I can give you a breakout room with the prosecutor if you wanted to.
I just have a question in general. What laptop?
That you'd have to contact the DA's office for. I don't get involved in evidentiary issues like that unless there's something filed with the court.
Okay.
ADA Petrus, is there anything?
call me with that specific.
Attorney Reitz, I don't think we heard everything that you said right there because
No.
it froze just a little bit.
It was saying nothing further, Judge.
Okay, understood. ADA Petrus, is there anything additional from your perspective?
No, I don't have anything else. Thank you.
Okay, then we have our scheduling for February 5th. Bond continues, and that's all for today. Thank you.
Thank you. I'm going to stay on because I've got Trinidad.
Yes, then we're calling Trinidad next.
Look, can you pull it?
No contact KBT, KMK.
Okay.
Cash on sign. Defense speaks lower streets that includes-
So I assume they're getting Mr. Trinidad.
You can
Have a lot of what's going this afternoon too. Mr. Trinidad, can you hear us? Okay. This is Brown County case number 20 CF 200, State of Wisconsin versus Adrian Emo Trinidad. The state is here by Assistant District Attorney Jessica Petrus. Attorney Brett Reitz is appearing. His client, Mr. Trinidad, is appearing by video from the Brown County Jail. I believe the DA's office has also made arrangements for the victim to appear on the case. The hearing is being done by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. This is on the calendar for a final pretrial. There is a jury trial date scheduled for Wednesday, February 24th. Attorney Reitz, is there anything to address today?
I have a question regarding bond. And I see that the victim is on. Is my recollection correct? There's the parties are seeking a bond modification, and maybe, and I know Katie, I know you can hear me. This is probably putting you on the spot, but is there a desire for a bond modification in terms of contact? Right now, it appears to only be written contact.
There's nothing filed with the court. The original bond from January 27th, 2020 is a $10,000 cash bond, no contact with KBT, KMK, or their residence or place of employment. Then the bond was modified February 4th to allow telephone contact with KMK while defendant is in the jail.
Well, that would be all I'd be asking for.
Oh,
So we're there. I'll
okay,
strike that.
that appears to be what the present state of bond is, yes. So that's up to the victim if they want to call the jail or not. So obviously, that doesn't not require her to talk to him at the jail. Understood?
Sure. No,
ADA Petrus, anything from the state?
No, thank you.
Okay. Should we set another final pretrial date?
We should.
How about Friday, February 19th? How does that look, Attorney Reeds?
That's wide open.
Let's do 11 o'clock.
Okay.
Friday, February 19th at 11 o'clock. If the victim would like to be heard on the scheduling, particularly if that date does not work for you, now would be the time to address the court. You're also free to continue to remain silent if you choose to do that.
No, that date works fine.
Thank you. Then bond continues, and that's all for today. Thank you.
Thank you, Your Honor.
And then we do have a 2 o'clock. Attorney John Herman. Latrina Turner. Latrina Turner. Well, we'll try contacting Attorney Herman. We have Attorney Herman. We unfortunately don't have Ms. Turner. You want to try calling her one last time?
Sure, I did speak with her actually less than about a half an hour ago. I'll try again.
Okay.
Judge, I couldn't reach her. Like I said, I did speak with her about a half an hour ago. Gave her the info, so I'm not sure what's going on.
Okay, well, let's call it. This is Brown County case numbers 20 CF 627, 20 CF 781, State of Wisconsin versus Latrina Lachey Turner. The state is here by Assistant District Attorney Jessica Petrus. Attorney John Herman is appearing. Ms. Turner does not appear. We're doing the hearing by video conference because of a global, national, and local public health emergency. We're live streaming on YouTube. The courthouse is open to the public, so any member of the community would be able to enter the courthouse unrestricted after passing a public health screen, but she does not appear in the courtroom here either. Attorney Herman, have you had recent contact with her?
Yes, Your Honor, I did speak with her on the phone today. I had given her the Zoom information. She was planning to appear by phone. I know she's been in contact with me. I think it might be an issue with her logging on because I know she has the information. I will tell the court we have an offer. Ms. Turner wanted me to talk to the assigned district attorney on this case just to see if there was a counter offer that we could agree on. Still, I know the case has been pending for a while, but we were going to ask for just one more opportunity to do that.
What's the state's position?
With respect to the non-appearance, I would note I do have a bit of a concern with the fact that Ms. Turner is currently not in compliance with CJS. I'm happy she's at least talking to Attorney Herman and has that contact established. But I do have some concern in light of both the non-appearance and the CJS non-compliance that she's currently experiencing.
She was in non-compliance, and then I sent out a notice that I send out to people that are not in compliance, basically telling them, giving them 7 days to be in compliance or a warrant will be issued. I think I actually did issue the warrant, but then she did become in compliance. It looks like it looks like on January 18th, it looks like she did become compliant by contacting CJS. So I think that's what is going to save her from having the bench warrant continue, because I'm not even sure if the bench warrant I issued has been quashed yet. So I will give her another court date because she appears to be presently in compliance and she has had very recent contact with her lawyer. If she doesn't appear at the next court date though, then a bench warrant would probably be the only option. So just to be clear, any bench warrant that's been issued can be quashed. And then for a court date, how about Monday, February 22nd at 3:30?
February 22nd at 3:30 would work. Thank you.
Anything additional from the state?
No, thank you, Judge. I do appreciate you making the full record with that too, because the CJS violation report I had was back from the end of December, so we didn't have that updated information.
Attorney Herman, anything else from your end?
No, thank you, Your Honor.
Then bond continues, and then that's all for today. Thank you.
Thank you.
Thank you.
And I think there's nothing until 2:30 now.
Sounds good.
If you could mute your device.
Hello?
If you could mute your device until your case is called, please. Sometimes
Okay.
*6 will act as a mute button, *6. As soon as we have Attorney Freilich signed on, I think we can call Mr. Slack's case. We just have one case at 2:30 and it's Anthony Slack. Mr. Slack, are you on the telephone?
No, this is Latrina Turner that's on here that you're talking to now.
Oh, okay, you're Miss Turner? Okay,
Yes, sir.
well, we're gonna give you the court date. We just gave you a different court date because you had recently talked to your attorney and you are now in compliance with criminal justice services. Let me find the date that we gave you.
And see,
February.
me and my criminal justice service lady had a miscommunication. She
Okay.
said that basically I was getting on her nerves because I was calling once a week, like I was over reporting, and then
Okay,
she changed
let
it
me-
to every other month.
Let me give you the court date. You ready to write it down?
Yes, sir.
Monday, February 22nd at 3:30.
February 22nd at 3:30. Okay.
Yeah.
Thank you, guys. I
And why don't-
appreciate it.
Why don't you call your lawyer right now and just tell him that you have a court date now?
Okay. Thank you.
Okay, thank you.
You have a nice day.
You too. Attorney Freilich, do we have you yet? Looks like you're still connecting to the audio. And that's Mr. Slack with you, Attorney Freilich? Oh,
Yes, Your Honor, good afternoon.
okay, we'll call your case. Good afternoon. This is Brown County case number 20 CF 1276, State of Wisconsin versus Anthony Slack. The state is here by Assistant District Attorney Jessica Petrus. Attorney Chris Freilich is here by video. With him in his office is Mr. Slack. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom. For everybody's health and safety, we are live streaming on YouTube. The courthouse is open to the public. There is no one in the courtroom gallery. Attorney Freilich, what is our status here today?
Your Honor, I've been meeting with Mr. Slack. He got here early at my office. We've been talking. The case is not resolved at this point. I do have an offer from the state. I have to review a Kobon video with my client, so we need a little more time.
How about Tuesday, March 9th at 4 o'clock?
Your Honor, I'm going to be on spring break on vacation that week, but I'll be back the week of March 15th.
How about Tuesday, March 23rd at 4 o'clock?
Sure, that's good.
Tuesday, March 23rd at 4 o'clock. And Mr. Slack, you heard that date and time?
Yes, sir.
Anything additional from the prosecutor?
No, thank you, Judge.
Attorney Freilich, anything else to address today?
No, Your Honor, thank you very much.
Then bond continues, and that's all for today. Thank you.
Okay. Thank you, sir. Thank you.
Thank you.
And then we have nothing until 3 o'clock now.
Sounds good.
There are 5 cases at 3 o'clock. If you could please mute your devices until your case is called. If you're calling in on a telephone, *6 will act as a mute button. *6 will act as a mute button. Calling in on- I think we'll call Mr. Duffy's case. He's at the jail. This is Brown County case numbers 20 CF 1807, 20 CM 691, 20 CM 1200. They're all state of Wisconsin versus Deshaun McKell Duffy. The state is here by Assistant District Attorney Jessica Petrus. Mr. Duffy is appearing by video from the Brown County Jail. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's safety. We are live streaming on YouTube. There's no one in the gallery. The felony file is on the calendar for an arraignment. Mr. Duffy, are you waiting for the public defender's office to appoint you an attorney?
Excuse me? I didn't hear what you said.
Are you waiting for the public defender's office to appoint you an attorney?
No, last time I checked, I was pro se.
Okay. I think this is the first time you're here on the felony case. So you do have the right to a lawyer. You can hire your own lawyer at your own expense. The benefit of that is that you can pick the lawyer you want. You can also the public defender's office or contact the public defender's office and see if you meet their financial qualifications. If you do not meet their financial qualifications, you can apply for a court-appointed attorney. The court will choose a lawyer for you. The county will pay the upfront expense, and you do have to repay the county over a reasonable period of time.
See, this the thing, Your Honor. I don't have the funds for a lawyer. That's why I pro se in the first place.
Okay. Well, that's what the public defender's office is for. Did you want to contact the public defender's office? Or would you like me to do it on your behalf?
No, because I'm innocent. See what I'm saying? Like, I just did my research. I seen my discovery. The problem is that the DA on this situation, she keep repeating that my DNA was a match. But as I'm reading my discovery,
we don't want to talk about the facts of the case. Based on what you said,
I'm basically being forced to go to trial right now, and I'm innocent.
Okay. It may be beneficial if you have a lawyer representing you. If the public defender's office puts something to you, the charges in this case are significant. The charges are a Class B felony, a Class C felony, and an additional misdemeanor. If you want to at least contact the public defender's office and see if you qualify.
No, I'm trying to tell you, there is no point of me having a public defender or anything when it's proven in my discovery that my DNA was not a match. My discovery tells me that my DNA was not a match, so there's no point of me taking it, of me waiting for a public. I've been waiting for over 30 days when I did want one, so I feel like ain't nothing gonna change. See what I'm saying? I've been waiting for the
Well,
longest for it. So, and
the-
then, you know what I'm saying? I didn't have the funds, so I'd rather pro se anyway.
Okay. You said in the past you wanted to have a public defender, but now you're choosing to go per se.
Yeah, and then I've been told them I was pro se. In my preliminary, I was pro se.
Okay. What I can tell you is that this is the first time the felony case is before me. I have had some success in the past locating attorneys, being proactive myself to contact attorneys, and they'll take a public defender's office appointment. Are you interested in me being a little bit more assertive to find you a lawyer?
Look, I sent the motion in for dismissal. I'm pro se. I know I'm innocent. I know I'm not guilty. I have very high beliefs that I have nothing to do with this situation. So I'm very confident in pro se.
Have you ever been represented by a lawyer in the past?
Yes, plenty of times. The 2 misdemeanor cases I caught 2019, I had a lawyer, John Peterson. He was just here.
Okay.
I had him, and then I had Kevin Martin, and I had Chad. But I resigned them because every time I would give a call out to these attorneys and these lawyers, they don't answer. They never answer the phone. They answer at their own discretion, which is, I feel, is unbelievable because I have, you know what I'm saying, like, just like everybody else got a life, I do too. So
you realize that lawyers do have specialized knowledge in criminal procedures. You understand that?
yeah, I understand that. I mean, it's understandable.
You understand that everything you say in court is being recorded by a court reporter and could be used against you.
Yeah, what how can they use it against me? And it's the truth. I'm not lying. I don't have to lie. I'm telling the truth.
So another benefit of having a lawyer is that they can speak on your behalf instead of you saying something that's going to be recorded in the court record.
Okay, but if I'm pro se, why would they want to just jump in my situation, in my case, and they ain't came to talk to me about nothing?
I'm not answering your questions. I'm just making sure that you're informed.
Okay, well, I'm pro se. That's what I'm trying to let you know. I'd rather pro se because I feel like, you know what I'm saying, either way it go with the attorney or not, the same information is going to be provided. And nothing's going to change.
How old are you right now?
I'm 20 years old.
You're 20 years old?
Yes, sir. Yes, Your Honor, I'm 20.
Do you have a high school diploma or an equivalency degree?
The thing is, I was going back into school around earlier 2020. Coronavirus hit, which shut everything down. So when that happened, you know what I'm saying, like, it got a little hard, a little rough. You know, my job was in and out on certain days, you know, which it kind of got hard. By the time the stuff started to open back up, I started, you know what I'm saying, me and my child's mother, we was bumping in, so I'm in and out of jail here and there. You know, I got out. I was trying to get back into school, you know, as I was, and kept, you know what I'm saying, trying to fight these cases. You know what I'm saying, which would make it hard.
You don't have an equivalency degree.
I do not.
Okay. Are you able to read and write English?
Yes.
And even with all this information, you still want to represent yourself?
Your Honor, I read my discovery and it's telling me my DNA is not applicable to the case information, which means they ran tests and it came back not applicable to every buccal swab. I have nothing to do with this situation. And they knew this since day one.
Then
you can read the transcripts yourself from my preliminary when the detective was stating the DNA came back on this day, and the DA saying, "Oh no, it came back on this day." And neither times that this DNA was a match to me, they put a warrant out for my arrest. See what I'm saying? That this being a 14-year-old female and I'm being 20 years old, no matter if it's consensual or not.
I'm going to cut you off. You're talking about the case too much, and it's not really relevant to what we're talking about here today.
I'm not guilty.
Okay. Did you want to enter a not guilty plea to the charge then today? That's one of the things we would do in arraignment.
Not guilty.
Okay.
That's what I'm saying.
There is the information that's been filed by the state that outlines the charges. Would you like that information read to you, or do you waive reading of that information?
What information?
The information just lists the charges. It's very similar to the criminal complaint, but it doesn't include any facts. It's literally just charges.
It's just charges, no evidence.
No evidence, and it includes the maximum penalties as well. Would you like me to read that document?
Was that the offer?
No, that's different than the offer. I don't know, and I'm not privy to what the offer is. I'm just asking you if you want me to read the information or if you waive reading before I enter the not guilty plea.
You can read it. I just want to hear what it. I don't know what it was.
Okay. You have a copy of it, Ethan?
Huh?
Count 1, first-degree sexual assault of a child under age 16 by use or threat of force or violence. Repeater, the above-named defendant between July 4th, 2020 and July 5th, 2020 in the city of Green Bay, Brown County, Wisconsin, did have sexual intercourse with a child who has not attained the age of 16, AAB, a 14-year-old child, by use or
Oh yeah. I got that.
do not cut me off at this point. Unless you want me to waive, unless you're going to waive reading of the information.
So that's not waiving anything. It's just waiving the reading, right?
Correct.
All right. I have that. I'll waive that and plead not guilty.
Okay. Then Mr. Duffy is waiving reading of the information. We'll enter the not guilty plea into the record on each count. I'll also make a finding that Mr. Duffy is knowingly and voluntarily waiving his right to an attorney at this point. I will tell him that he is free to change his mind if he'd like to be represented by an attorney in the future. You do have to notify the DA's office and the court if you decide to go to the public defender's office or hire your own lawyer so that we know to talk to that lawyer instead of talking to you directly. Mr. Duffy is 20 years old. He's very young. He does not have a high school degree or an equivalency degree. He says that he does understand English. He reads and writes English. He does articulate himself very well. He speaks very fluently to the court, and he was very responsive to my questions and answering them promptly as well. So I don't have any reason to question his competency, and that he is freely and voluntarily waiving his right to an attorney at this point. And then you said that you filed motions.
Yeah, I sent one out before, but I don't know. I didn't do it correctly. I was showed the proper way to file a motion, and I did get a notary on it, so I sent it out Saturday. I don't know. It should be there today or tomorrow, maybe Wednesday.
I do see them in the court's file. Yes. How about Monday, February 15th at 2:30?
For the motion hearing?
Yeah, for arguments on the motion.
Could you get anything before that, like the 13th or like the 10th? Something like around there?
Well, the 10th is a jury trial date, so I can't do that. 13th is a Saturday, I believe, so I can't do that either. Monday, February 15th is actually a very quick scheduling. That's only a couple weeks.
All right.
Anything additional from the state?
Yes, there are a few things I'd like to make a record about. So just to clarify for that motion hearing, that would be the court hearing the motion to suppress DNA evidence that Mr. Duffy filed?
Yes.
Okay. The only other thing I want to clarify is that Mr. Duffy also sent a filing for all discovery. I would just like to note for the record, so it's clear, the state has sent discovery to Mr. Duffy, and we have confirmed that he does have all the discovery on the case currently. So that should address that issue.
Oh yeah, Your Honor, one thing I have, I did see my discovery, but it was on a disc. It was like a CD. Like, is there a way that I can get it in paper? So like, you know what I'm saying? Because I'll be in my own cell. Like I can't see when I want to see. I'm pro se. You know, I'm my own, basically my own attorney, my own lawyer. And I have limited chances to fight my case right now. I don't see why I'm being told, no, I gotta wait to see my discovery. You know what I'm saying? I can't, ain't no way that I can prove this. If I have to go to trial, you know what I'm saying, prove this to the court, you know what I'm saying, that my DNA was not applicable. So how would I do that without having that evidence?
ADA Petrus, do you know the answer whether the DA's office can accommodate a paper copy for somebody in custody?
I will double check. I think we should be able to, but I'll check with our discovery clerk and the attorney who's assigned to this case.
Okay. Just let you know, Mr. Duffy, they can charge a fee for paper copies, which might come out of your jail account. They might be authorized to be able to do that. Just let them know that.
All right, and the motion was a motion for dismissal.
How many motions did you file? How many different ones?
I only filed one correct motion, which had the motion. They told me that then when you send out a motion, it has to have a notary. I only sent out one motion for dismissal with the notary, and that was on Saturday, which should be there either today or tomorrow. I don't know if it made it there today, but it takes about 2-3 days for mail to be, you know what I'm saying, sent out. So it was
It has not made it into the court's file yet, but my staff will keep an eye out for it.
It was a motion for dismissal.
Okay.
So
Then bond continues and we'll be back on February 15th. Thank you.
I'm sorry, I do have one more thing I want to quick bring up too.
Okay.
With respect to the 2 misdemeanor files, I believe Attorney Fahrenkrug and Attorney Martin are still on those. I'm not sure if they were intending to appear today for the hearing or what the status is. I don't know if they intended to withdraw or really what's going on with the misdemeanor files, but just so the court knows, there are 2 attorneys on those cases.
they withdraw. At my preliminary hearing, they were not present. They remember Legois at my last court date when 88 Hannah Stewart she was there.
Did you call me Lee Joyce?
I don't know how to properly, excuse me. I don't know how to properly.
Just call me Judge. Call me Judge, please.
Your Honor.
Your Honor. So
look, so they resigned from. I called the DA. This is around the time I was looking for a judge. I'm steady asking them. Y'all I found a
not Attorney Martin on the spot, but he is on the call. Attorney Martin, are you there? Attorney Martin, do we have you?
Yes, Judge Joyce, sorry about that.
Jashawn, are you representing him anymore?
No, I believe there's a conflict. I think. Let me double check.
Okay. Like Attorney Martin is going to look up the status, and I guess does it look like you're looking for an attorney for him right now in your system?
Yeah, let me check. Yeah, let me check.
See what I was saying? Because they tell me one thing and then it's a whole nother thing. So I'm not understanding this.
What did they tell you, Mr. Duffy?
Y'all said, both of y'all, I was told y'all resigned. And when I spoke to the clerk lady from the DA district attorney office, she said that you want to pro se both of those cases. And I said, well, yeah, because every time I try to get in contact with these attorneys, I don't get no call back.
Okay, it sounds like you want to go pro se on the misdemeanor cases also.
Last time I heard, I was pro se.
Yeah, that's my recollection. Yep.
Okay, everybody needs to be quiet right now. So thank you, Attorney Martin, for accommodating, because we can't have more than one person talking because the court reporter. ADA Petrus, is there anything else from the state's perspective?
I'm sorry, the last thing I just missed was the time for that motion hearing on the 15th.
It was Monday, February 15th at 2:30.
Okay, and is that in person or over Zoom?
Over Zoom.
Okay, thank you. I don't have anything else.
Okay, then bond continues, and that's all for today on Mr. Duffy's case. Thank you.
Thank you.
Then Attorney Freilich, I see you with your client. Is that correct?
We're both here. Yes, that's correct. We're here.
And that's Mr. Dockstader?
Yes, Your Honor.
This is Brown County case number 20 CF 786, State of Wisconsin versus Richard Martin Dockstader. The state is here by Assistant District Attorney Jessica Petrus. Attorney Chris Freilich is appearing by video. With him is his client, Mr. Dockstader. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Freilich, what is our status here today?
Your Honor, thank you. The matter is not resolved. I do have discovery. I provided my client with a copy of it. We'd like to set the matter over for about 30 days or so.
What about Tuesday, March 23rd at 3:30? I think I gave you 4 o'clock earlier today. What about 3:30 for this hearing? Unless you want to do them both at 4 o'clock.
Yeah, we could do both at 4 o'clock. That's fine.
Okay, Tuesday, March 23rd at 4 o'clock, and your client heard that as well?
Yes, he did.
Anything additional from the state?
Oh, thank you, Judge.
Then bond continues, and that's all for today. Thank you.
Okay, thank you.
Attorney Peterson, do we have your client on?
I'm not sure if
Whitaker,
she's on or not.
Hope
Yes,
Whitaker?
I'm here.
Yes, she
Okay.
is. Okay.
This is Brown County case numbers 19 CF 1608, 20 CF 122, State of Wisconsin versus Hope Elizabeth Whitaker. The state is here by Assistant District Attorney Jessica Petrus. Attorney John Peterson is appearing by video. We also have Ms. Whitaker appearing by video as well. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Peterson, what is our status here today?
Judge, we're going to be resolving this, I believe, but I wasn't able to get in touch with my client, or I should say meet with my client because I had to be quarantined. So, and I literally just got back a couple hours ago. So if we can get another court date, hopefully we can have this resolved at that time.
How about Friday, March 12th at 10:30?
I don't think I'm going to be available on the 12th. Is there maybe the 11th?
The entire day on the 12th?
Correct.
How about Friday, March 26th at 10 o'clock?
Said March 26th?
Yes.
That should be fine.
Friday, March 26th at 10 o'clock. Ms. Whitaker, did you hear that date and time?
Yes, Your Honor.
Anything additional from the state?
No, thank you, Your Honor.
Then bond continues, and that's all for today on this case. Thank you.
Just to be clear, that was 10 o'clock, Judge, right?
Yes.
Thank you very much.
Thank you.
Thank you. And Attorney Martin.
Oh, yes, sir.
Kevin Bourne. Kevin Bourne.
Yes, Mr. Board, are you there on, I don't see his phone number. I don't know if he's on the Moto E6 or.
Kevin Bourne. If you're on the call, unmute your device and your case can be called. Kevin Bourne.
I just talked to him this morning. I can give him a phone call.
Hello?
Okay, sounds like we have. You're Mr. Bourne?
Yes.
Okay. This is Brown County case numbers 19 CM 1604, 20 CM 277, 20 CM 721. And if you can mute your device again, reduce the background noise. Okay. State of Wisconsin versus Michael Bourne. The state is here by Assistant District Attorney Jessica Petrus. Attorney Kevin Martin is here. Mr. Bourne is appearing by telephone. We're doing the hearing by phone and video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There's no one in the courtroom gallery. Attorney Martin, what is our status here today?
Oh, yes, thank you, Your Honor. This case is not resolved. We had reached out to Assistant District Attorney Lucher with a counteroffer. Still waiting to hear back from him. I don't think it's an outrageous counteroffer. I think it's reasonable. I think we're close to resolving this. Just got to hear back from him. I'd ask for another court date, I guess in March or April.
About Monday, March 8th at 1:30?
Monday, March 8th
Yeah.
at 1:30. Let me check. 9:30. Oh, I can't do Monday, March 8th at 1:30. I got a juvenile intake and then adult intake that day. So my afternoon's all booked up.
How about at 9:30?
Monday, March 8th at 9:30?
Yes.
Yep, that works for me.
Monday, March 8th at 9:30. And Mr. Bourne, I did have to mute your device to reduce the background. Are you able to unmute it again?
Yes, I heard that.
Okay, great, thank you. Anything additional from the state?
No, thank you.
Then bond continues, and that's all for today. Thank you.
Thank you.
Your Honor,
Yes,
I was just on the phone with my client Wayne Hoffman. He's currently at Sand Ridge. I believe we have to call him.
okay,
So he's at 3:30 though. If you have something else, I just wanted to make sure we were going to call him.
okay, thank you. Okay. Attorney Michalowski, are you on the call?
Yes, Judge, I'm here.
Is yours going to be quick or something else?
We just need a date, Judge.
Okay. Felix Rivera Medina, are you on the call? Felix Rivera Medina? Felix Rivera Medina. There's one additional phone number that looks like it's muted. If this is Mr. Rivera Medina, unmute your device now. Your case is being called. Felix Rivera Medina. Then we'll call the case. This is Brown County case number 19 CM 1489, State of Wisconsin versus Felix Luis Rivera Medina. The state is here by Assistant District Attorney Jessica Petrus. The attorney David Michalowski is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. The courthouse is open to the public, so he would be able to walk into the courtroom unrestricted, and he does not appear in the courtroom or on the video conference. Attorney Michalowski, have you had recent contact with your client?
Yes, Judge. Actually, I just spoke with him earlier today. I'm not sure what the phone number that you see I'm not sure if it's 608-432-4841.
There's no 608 numbers.
Okay, I just spoke with him. If you want, I could reach out to him again. I just texted him the information earlier, so I'm not sure if he's experiencing some technical difficulties, but I just want to let the court know that we have reached a resolution and we're just looking for a date for a plea and sentence.
Okay. He has repeatedly made court appearances on this case, and it looks like he is required to participate in criminal justice services, and there's no indication that he's not in compliance. And our criminal justice services usually is pretty on top of it when somebody's not in compliance to notify the court. Does the state have any additional information?
No, I don't.
Okay. I think I'm just going to give you a court date then, because he appears to be in compliance with EJS. You've talked to him recently, and he hasn't missed court in the past on this case. And if he does not appear at the next court date, then bench warrant would probably be the only option. How about Friday, March 12th at 10:30?
One moment, please. Let me check. Friday, March 12th. And did you say, Your Honor, 10:30?
Yes.
Yes, Friday, March 12th at 10:30 should work for the plea and sentence.
And that'll be for a plea and sentencing, so we'll have a sufficient time block. And then bond continues, and that's all for today. Thank you.
Thank you.
Okay, let's call into Sand Ridge. Are you Wayne Hoffman?
Yes, sir.
Okay, I think we're ready to call your case. This is Brown County case numbers 19 CF 1596, 19 CF 1597, 19 CM 1280. They're all state of Wisconsin versus Wayne J. Hoffman. The state is here by Assistant District Attorney Jessica Petrus. Attorney Tricia Fritz is here. Mr. Hoffman is appearing by video from Sand Ridge Correctional Facility. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. And I know Deputy District Attorney Wendy Lemkool is assigned to this case. DDA Lemkool, are you appearing for Wayne Hoffman's case?
I am.
Okay, we literally just called it. All we did was introduce the parties.
Thank you.
Attorney Fritz, what is our status on this case today?
Your Honor, I don't think we have reached a resolution at this point. If we could schedule for a jury trial, please.
The first reasonable date, I think, would be March 10th, which is a Wednesday, then every 2 weeks after that. So that'd be March 24th, April 7th, April 21st, May 3rd, May 5th, not May 3rd. May 5th would be the only one that does not have many cases put on already.
I cannot do May 5th.
April 21st also only has one case scheduled.
I like that.
Okay, April, you want Wednesday, April 21st for the trial date?
Let me look a minute, Your Honor. Actually, Your Honor, I have a sexual assault in your branch on Terry Mays that could go.
It is the only other case for Wednesday, April 21st. So obviously only one of them would actually go. I don't recall if Mr. Mays was in custody or not.
He's not.
Would you prefer to have a different date, or would you like them both put on the schedule that day?
I guess I'm okay with putting that on.
Then Wednesday, April 21st, starting at 8:30. All three cases would be on the trial calendar, and the state would decide which case tries first because they have the burden of proof. The jury selection would be Wednesday, April 20th at 1:30. How about we have a final conference on Tuesday, March 23rd at 3 o'clock?
That's fine.
Anything additional from the state?
No, we would just ask for a panel and a half or 2 panels based upon whichever one of my trials would go with sexual assaults and with
Okay.
COVID.
A panel and a half or 2 panels?
Yes, please.
Okay. Attorney Fritz, anything from your perspective?
Your Honor, I've already told my client this, but as I'm leaving the public defender's office on February 12th, I have to close out this file. I am looking to get it reappointed to me as a private bar attorney. It may take a few days, but just so the court is aware, if you see that I'm trying to get off the case, it means I will be back on the case. So please don't decline that case completion.
Okay. But we still wanted to schedule it for trial today, though, when the trial date might not be available to subsequent counsel?
It's me. I'm subsequent counsel.
Oh, you said that you are going to be. Okay, I see. I get it now. Then bond continues, and that's all for today. Thank you.
Thank you.
Attorney Simon, is your case going to be anything other than scheduling?
Unfortunately, no.
Is it a plea and sentencing?
I mean, unfortunately, no, it's nothing more than rescheduling.
Oh, okay, because I'll call your case right now if it's gonna be quick.
It will be.
This Colin Gill, I assume that's him right there.
Yes,
Is that
sir,
fine?
in the blue plaid shirt.
Yes, Your Honor. Brown County case number 20 CF 939, State of Wisconsin versus Colin James Gill. The state is here by Assistant District Attorney Jessica Petrus. Attorney Todd Simon is here. Mr. Gill is appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Simon, what is our status here today?
Your Honor, I last spoke with the assigned prosecutor in, I believe it was mid-December. And at that time, I was to talk to my client and get back to the DA with information. And since that time, I have talked to my client, but I'm having a very hard time getting a hold of the assigned DA. Unfortunately, with everyone working from home, all I can do is send emails, and I haven't been able to touch base with her.
For scheduling, how about Tuesday, March 9th at 4 o'clock?
I'm scheduled for a trial that day in Branch 5.
How about Monday, March 8th at 10:30?
I'm in Oconto County that morning, and then I'm in jury selection in the afternoon.
How about Tuesday, March 23rd at 2 o'clock?
March 3rd at, March 23rd will be fine.
March 23rd at 2 o'clock. Did you hear that, Mr. Gill?
Yes, I did, Your Honor.
Anything additional from the state?
So you know, Attorney Simon, for contacting Attorney Potsky, most days she is in the office downtown. So it might be easier to call the office phone for her.
Can you do me the courtesy of maybe putting a note in your file too?
I can do that.
Thank you.
Then bond continues, and that's all for today. Thank you.
Thank you.
Thank you, Your Honor.
Palo Landry? Palo
Yes.
Landry? Okay. This is Brown County case numbers 20 CM 1318, 20 CM 1474. State of Wisconsin versus Palo Sabri Landry. The state is here by Assistant District Attorney Jessica Petrus. Attorney Abby Jansen is here. Her client, Mr. Landry, is appearing by telephone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Jansen, what is our status here today?
Thank you, Your Honor. We have received discovery in both cases. However, we have not yet received an offer. So at this point, we would just be asking that the court schedule an additional pretrial conference.
Is there an offer in the state's file that can be provided after court?
I don't believe so. We just received an additional referral this morning, but Attorney Schuckert, who's assigned to this, is currently preparing for a jury trial that's going this week. If Attorney Jansen wants to reach out to her possibly next week on the new referral, they can coordinate a global offer for that.
Then for scheduling, how about Tuesday, March 9th at 4 o'clock?
Just 1 second, please. I am scheduled for a jury trial that day, Your Honor.
Are you available Monday, March 8th at 3 o'clock?
Yes.
Monday, March 8th at 3 o'clock, using the same video conference procedure. Did you hear the date and time, Mr. Landry?
Yes, March 8th at 4 o'clock.
At 3 o'clock, March 8th at 3 o'clock.
Okay.
Anything additional from the state?
No, thank you.
Bond continues, and that's all for today. Thank you.
Thank you.
Dean O'Connell. And you're with your client, Attorney DeKotch?
Yes, Judge, we just need a new date on this.
Okay. This is Brown County case numbers 20 CF 758, 20 CF 927, 20 CF 483. They're all State of Wisconsin versus Dean Paul O'Connell. The state is here by Assistant District Attorney Jessica Petrus. Attorney Clarence DeKotch is here by video. With him on video is his client, Mr. O'Connell. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney DeKotch, what is our status here today?
Thank you, Judge. I received an offer on 20 CF 483 and 758. I'm still waiting to discuss an offer on the other matter. If we could have another date within 30 to 45 days.
How about Friday, March 12th at 2:30?
I will be out that week.
Friday, March 26th at 10:30.
I have a trial scheduled.
What if we have it later in the day on Friday? Would that be helpful?
No, that trial's in, I believe, Walworth County.
What day does that trial start? Like, are you available on Tuesday, the 23rd?
Yes, I am.
How about at 3:30?
That works.
Tuesday, March 23rd at 3:30. You heard that date and time, Mr. O'Connell?
Yes, Your Honor.
Anything additional from the state?
No, thank you.
Attorney DeKotch, anything additional?
No, Your Honor, thank you.
Then bond continues, and that's all for today. Thank you. And then Ashley Ramirez.
Yes.
And we have Attorney Fahrenkrug as well, so we'll call that case. This is Brown County case number 20 CM 520, State of Wisconsin versus Ashley Naomi Ramirez. The state is here by Assistant District Attorney Jessica Petrus. Attorney Chad Fahrenkrug is here. Ms. Ramirez is appearing by telephone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Fahrenkrug, what is our status here today?
I believe we sent out a counter offer. I don't know that I've received a response from it. We were kind of in a trial position, unless there was a substantial reason for my client to settle. I don't know that that's actually happened. That May 5th date, I think, would work for us for a jury trial. The April 20th date would work. I think that's for jury selection.
You said that you gave DA's office a counter offer. Is that what you said?
I believe so. Yes.
Okay. Well, let's ask the state if they have first received it and if it's been considered.
I would note, there's a note from Attorney Schuckert, who this case is assigned to, from today's date at 11:42, indicating that she had not received a counter offer, and that she would be sticking with the current offer in the case as is.
But she hadn't received it though?
No, I don't believe so.
Okay.
It would have been months. It would have been months old, so I can reach back out to her.
Okay. Because the fact of the matter is that a misdemeanor disorderly conduct with an individual who's not in custody is going to be a
low priority.
The lowest priority trial I would have. So I think I would prefer to give you another status conference date to make sure just to give you another opportunity to exhaust all of your negotiating, if you're okay with that.
That's fine, Your Honor.
About Tuesday, March 9th at 4 o'clock. Attorney Fahrenkrug, does that date work for you?
I'm working on my calendar, yeah.
Okay. It does work for you?
I'm bringing up my calendar.
Oh, okay. I heard you now.
March 9th works.
Okay. Tuesday, March 9th at 4 o'clock. Did you get that date and time, Ms. Ramirez?
Yes.
Okay. Then anything additional from the state?
No, thank you.
Bond continues, and that's all for today. Thank you.
Thank you, Judge.
Attorney Petrowski, I see you're on the call. Are you with your client?
Yes, Judge, he is here present with me at my office.
It is a 4 o'clock case. Is there a victim on the case that you're aware of?
There is not, Your Honor. This would be an OWI third offense.
Are you planning on doing a plea and sentencing today?
Yes, Your Honor. My client is prepared to report. I have submitted
Let's go on the record, because I'm going to just re-ask all the questions anyway.
No problem, Judge.
ADA Petrus, are you okay with calling the case early?
That's fine.
This is Brown County case number 20 CT 8, State of Wisconsin versus Daniel Gerard Barrett, and 20 TR 588, Brown County versus Daniel G. Barrett. The state is here by Assistant District Attorney Jessica Petrus. Attorney Randall Petrowski is here. His client, Mr. Barrett, is appearing by video, and they're at Attorney Petrowski's office together, it appears. The hearing is being done by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. There is a plea questionnaire that was submitted by Attorney Petrowski. And is it the intent here today, Attorney Petrowski, for a no contest plea to count 1, operating while under the influence, third offense?
That's correct, Your Honor. I can also represent, I filed a pattern jury instruction that I believe will be coming through shortly after the questionnaire, reflecting the elements required for the state to prove OWI as a third offense.
Is that one through yet?
If it has not, Your Honor, I did send a courtesy email attaching both to you and Attorney Hillman. I could forward that to Attorney Petrus if she'd like as well.
But you did review the elements with your client?
Yes, Your Honor.
Okay. Is that the state's understanding of the plea agreement in this case?
I'm sorry, just to clarify, that was a plea to count 1, dismissing count 2, correct?
That's correct.
Okay.
And then
That
what would
is-
happen to the TR file? What would happen to the TR file?
The TR is a refusal, and I know it's typically not our office policy to dismiss those.
Okay. Attorney Petrowski, is that your understanding?
Bear with me for a second. I have to review the email from or the offer from Attorney Hillman. You could bear with me for just a moment, Your Honor. I'm looking for that as we speak. Your Honor, it appears that the offer is silent as to that issue. Could we have a breakout room?
Yes. So both the ADA Petrus, Attorney Petrowski, and his client are now speaking privately in a breakout room. We're on the record in a different case. The lawyers are talking privately in a breakout room, and we don't have any other lawyers signed on, so please just stand by and we'll call your case when it's ready.
Okay.
I am going to mute the feed though, so that there's no background noise. Attorney Stebbins, are you there?
Yes,
Are we just scheduling on your case?
yes, but may I have a breakout room just to update my client?
Oh, I made the mistake of only opening one and it's already occupied.
Okay. I mean, would you allow us? Well, I should probably speak to him before we go on the record.
Okay. Attorney Freilich, do we have you? Attorney Freilich, are you there with your client?
His client's here. I'm going to get him right now.
Okay. Oh, okay, we're back on the other case now, so I can send Attorney Stebbins there. Okay, Mr. Jiang, if you could accept the breakout room request. Attorney Freilich, you got a couple cases, right?
Yes, Your Honor.
Are we doing anything other than scheduling on those two?
Well, on the other case, this is Mr. Kelly. We're just
Okay.
gonna reschedule him. We're gonna reschedule him.
And then what about on
Yep,
Oligny?
I mean,
and
Yeah, we're
That
gonna
was
enter
gonna
a not, we're gonna enter a plea on that one.
Okay. Well, we can call Mr. Kelly's case right now to get that one closed out for the
Okay.
day. And then we're gonna go to Attorney Petrowski after that.
It's fine.
This is Brown County case number 20 CF 330, State of Wisconsin versus Justin Ezra Kelly. The state is here by Assistant District Attorney Jessica Petrus. Attorney Chris Freilich is here. His client, Mr. Kelly, is attending with him on video conference. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Freilich, what is our status on this case?
Your Honor, the case is not resolved at this point. I'd like to amend my client's plea after talking to him. He has received mental health treatment through Brown County Mental Health. And I'm gonna ask that our plea be changed to not guilty and not guilty by reason of mental disease or defect, the NGI plea.
The state take any position on it?
No.
And then Attorney Freilich, do I enter an NGI for in order to do an NGI evaluation then?
Yes,
If
Your Honor.
it's not opposing? Then based on the representations of Mr. or Attorney Freilich about his client, I will order an NGI evaluation to be completed.
Your Honor, would that be by the Wisconsin Forensic Unit?
Who was it done by? The independent provider through DHS.
Oh, okay.
And then does anybody know the time limit for the next hearing to be done? I know what it is for a competency evaluation, but not for NGI. Off the top of my head anyway.
That 30 days?
If everybody can mute your devices so that there's no background noise, please mute your device. Okay, I believe the statute says it just has to be done within, not before 10 days before trial. I don't think we have a trial date yet. So I think it does not look like there's a date for the report being due other than that. So for scheduling, how about Monday, March 8th at 3:30 for a status conference. Although you're gone that week, isn't that the week you're gone?
Your Honor, you got a good memory. Yes, I'm gone that week.
And how about Monday, March 22nd? Although I think you're already here, Tuesday, March 23rd at 4 o'clock, if you want to keep going with that time slot.
Yeah, Your Honor, I am there on March 23rd.
Tuesday, March 23rd at 4 o'clock.
Okay, that's good.
And the doctor's report will have due Friday, February 26th. Anything additional from the state?
No, thank you.
Then bond continues, and that's all for today on Mr. Kelly's case.
Okay, thank you.
Attorney Crosby, are we doing anything other than scheduling on your case?
No, Judge, just scheduling.
We'll call that one real quick then. This is Brown County case numbers 20 CT 209, 20 CT 1068. They're both state of Wisconsin versus Dominic Jaquise Hart. The state is here by Assistant District Attorney Jessica Petrus. Attorney Michael Crosby is here. Mr. Hart is appearing by video conference. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There's no one in the courtroom gallery. Attorney Crosby, what is our status here today?
Thank you, Your Honor. At this point, I'd ask you to schedule it out for another clear status. We received an offer in the case. It contemplates Mr. Hart getting his driver's license. He's still working on that. There's also an additional file that it's unclear if I've been appointed to represent him on it yet. So I'd ask that you just set it out another 30 days for a clear status to verify counsel and to give Mr. Hart a chance to some more time to work on getting his license.
How about Tuesday, March 23rd at 3:30?
I have is there another time, Judge?
Monday, March 22nd at 3:30.
I have a jury selection and then a trial on those 2 days. That's is there another time that week maybe? Or maybe Monday in the morning?
Monday in the morning would work at 10:30.
I think that works, Your Honor. Thank you.
Monday, March 22nd at 10:30. Mr. Hart, did you hear that?
Yes.
Anything additional from the state?
No, thank you.
And bond continues, and that's all for today. Thank you.
Thank you very much.
Attorney Stebbins, is your case ready if you're just doing scheduling?
Yes, Your Honor.
This is Brown County case number 20 CF 532, 20 CM 353, State of Wisconsin versus Chineng Jiang. The state is here by Assistant District Attorney Jessica Petrus. Attorney Scott Stebbins is here. Mr. Jiang is appearing by video from the Brown County Jail. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Stebbins, what is our status here today?
Thank you, Your Honor. I believe I advised the court the last time that I had completed the review of the written discovery materials. There was reference to a squad video that I thought was important to review as it relates to a potential motion issue. I've received that. I've reviewed it. I haven't had a chance to follow up with Attorney Potsky, though. I think we'll be able to resolve this. We're not there yet, But at this point, I would just ask that we schedule this for a status/potential plea in approximately 45 to 60 days.
How about Friday, March 12th at 2:30?
I have a hearing in branch 7 at that exact time.
11:30 or 3:30 would also be open.
Let's do 11:30, please.
Friday, March 12th at 11:30. Anything additional from the state?
No, thank you.
Then bond continues, and that's all for Mr. Jiang's case. Thank you.
Take care, Mr. Zhang.
Yep. I know.
Okay.
And then back to Attorney Petrowski.
Yes, Your Honor.
We're back on the record for the case with Daniel Barrett. The state is here by ADA Petrus. We have Attorney Petrowski. We also have Mr. Barrett now. I think we were talking about what's going to happen to the TR file. ADA Petrus.
Thank you, Judge. Attorney Petrowski and I did have a chance to discuss that. It's the Brown County DA's office policy that we don't dismiss refusals as part of pleas and OWIs. And I believe Attorney Petrowski would like to be heard further on that matter once we get to that point.
Attorney Petrowski.
Yes, Your Honor. The court has the ability to dismiss refusals in circumstances where the defendant is pleading to the underlying OWI, and I plan to make an argument to that effect once we get to the sentencing portion of the case.
Okay. Are we ready to go forward with the plea then?
Yes, Your Honor.
And did you talk to your client about the video conference appearance?
I did, Your Honor, and he's willing to waive his in-person appearance and appear via video conferencing today.
Is that correct, Mr. Barrett?
That is correct.
So you do have a right to be present in person, and you're waiving that right to be present in person so we can appear by the video conference?
Yes, I am.
And you're in the same room as your lawyer, right?
Yes, I am, Your Honor.
So if you need to talk to him privately, it's just as simple as muting your device, then you can talk to him privately, understood?
That is correct. Yes.
And is it your intent to plead no contest today to operating a motor vehicle while under the influence, third offense?
Yes, it is, Your Honor.
And I guess one clarifying question for the lawyers is what happens to the alcohol fine enhancer? Is that just staying on? ADA Petrus?
Judge, my notes don't specifically mention anything about it. I'm not sure if that's something that Attorney Petrowski discussed with Attorney Hillman.
I believe as part of the agreement for the state to come to the left side guidelines, that would be staying on, yes.
Okay.
Thank you.
First, a required warning I have to give Mr. Barrett is that if you are not a citizen of the United States of America, you are advised that a plea of guilty or no contest for the offense with which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law. Do you understand that?
I do understand that.
Have you had sufficient time to review this plea form with your lawyer?
Yes, I have.
Have you had sufficient time to review the criminal complaint in this case with your lawyer?
Yes, I have.
According to the plea form, you are 52 years old. Is that correct?
That is correct.
And you do have a high school diploma or an equivalency degree?
Yes, I do.
It says 12 plus years for schooling. Have you had schooling after high school too?
Yes, I did take some college courses through the University of Phoenix, Your Honor.
Okay. And
Wait.
it sounds like you do understand English, correct?
Yes, I do, Your Honor.
According to the plea form, you are not currently receiving treatment for mental illness or disorder. Is that correct?
That is correct.
And you have not had any alcohol, medications, or other drugs in the last 24 hours. Is that correct? That's correct?
That is correct. Yes, Your Honor.
The charge in count 1 of the criminal complaint is operating a motor vehicle while under the influence, third offense, with the general alcohol concentration enhancer. The maximum penalty is 1 year in the jail or a $2,000 fine or both. Do you understand that's the maximum penalty?
Yes, I do, Your Honor.
And then there's a minimum penalty required of 45 days jail and a $600 fine. Do you understand that both of those are mandatory minimum penalties?
Yes, I do, Your Honor.
The elements of operating a motor vehicle while under the influence are first, that you operated a vehicle on a public highway. Second, at the time you operated the vehicle, you were under the influence of an intoxicant. Do you understand those are the maximum, or those are the elements of the offense? Do you understand that?
Yes, I do.
In the criminal complaint, the state asserts that you have 2 prior convictions. They have offense dates of October 19th, 2003 and June 22nd, 2008, with convictions on November 5th, 2003 and October 24th, 2008. Do you agree that you have 2 prior convictions for operating a motor vehicle while under the influence?
I do, Your Honor.
And do you understand that I could sentence you up to the maximum penalty? Do you understand?
Yes, I do, Your Honor.
And if I placed you on probation and your probation is later revoked and you have to come back to me for sentencing again after revocation, do you understand I could sentence you up to the maximum penalty at that time?
Yes, I do, Your Honor.
The criminal complaint includes the facts that the state believes are true. Do you agree that there are enough facts in the criminal complaint to support your no contest plea to this charge?
Yes, I do, Your Honor.
Your constitutional rights are the right to a jury trial where all 12 jurors would have to agree that you're either guilty or not guilty. Your right to remain silent, your right to testify and present evidence, your right to use subpoenas to require witnesses to come to court, your right to confront and cross-examine witnesses who testify in court, and your right to make the state prove that you're guilty beyond a reasonable doubt. You understand you'd be giving up those rights by entering a no contest plea.
Yes, I do, Your Honor.
Do you understand that I will find you guilty if I accept your no contest plea?
Yes, I do, Your Honor.
Are you doing this of your own free will?
Yes, I am.
Has anybody put any pressure on you or forced you to make this plea?
No, sir, they have not.
And I guess I should verify that you understand that the charge is a misdemeanor offense. Do you understand that?
Yes, I do, Your Honor.
Attorney Petrowski, are you satisfied your client is freely, voluntarily, intelligently, and knowingly making this plea?
Yes, Judge, I am.
Are you satisfied he understands the elements, the facts, and the rights he is giving up?
Yes, Your Honor.
Then, Mr. Barrett, are you prepared to enter a plea at this time?
Yes, Your Honor, I am.
Do you have any questions about anything that we've talked about here today?
I do not, Your Honor.
Then to the charge in count 1, misdemeanor operating a motor vehicle while under the influence, third offense, what is your plea?
No contest, Your Honor.
I will accept the no contest plea. I'll find that it's been freely, voluntarily, intelligently, and knowingly made. I'll find that Mr. Barrett understands the elements of the crime, the facts that support the elements, and the rights that he is giving up. I will find him guilty of the offense and order judgment of conviction entered into the record. And I guess as to the refusal offense, Attorney Petrowski, I mean, I guess you still have the right, you can have a trial on the refusal, I suppose, even after the plea that we've made here today.
That's true, Your Honor.
And then I am aware that there's a case that says the court can basically dismiss it on the court's own volition, and that's what you're going to be arguing?
That's correct, Your Honor.
Okay. Why don't I hear the state's sentencing argument first?
Thank you, Judge. With respect to the OWI third, the parties actually have a joint recommendation for the left-sided guidelines for a BAC of 0.190. That would include 110 days jail, a $1,200 fine plus costs totaling $2,502, 30 months revocation of driver's license, 30 months imposition of ignition interlock device, AODA, and a blood draw fee in the amount of $46.50. I would note, as Attorney Petrowski and I were talking earlier in the breakout room, he indicated that his client does live in the Madison area. So I would just note at the outset that the state doesn't have any objection to Mr. Barrett serving that sentence in a different county. With respect to the facts of this case, on January 7th of 2020 at around 6 p.m., officers were dispatched to the area of Lombardy Avenue and Marley Lane for a report of a reckless driver. The complainant indicated that the driver was swerving. The officers made contact with the vehicle in question, which was found in the parking lot of the Hilton Garden Inn, and Mr. Barrett was the driver. Officers noted a strong odor of intoxicants coming from the vehicle when they made contact with him, and also noted that Mr. Barrett had glossy eyes and slurred speech, and he did admit to consuming a few Miller Lights. He was transported to the police department to perform field sobriety tests. He did perform the HGN test, of which 6 out of 6 clues were observed, but refused to perform the walk and turn, one leg stand, or PBT, and then subsequently refused to submit to the blood draw later. One of the officers who responded did speak with the complainant, who indicated that they saw Mr. Barrett stumble out of Red Lobster and that he subsequently almost backed into her vehicle and then was driving very slowly down Lombardy Avenue and was also swerving back and forth. I would note, with respect to a prior record, Mr. Barrett's only prior convictions are for OWIs, and they are quite dated. His OWI first is from 2003, and his OWI second is from 2008. So there is certainly quite a bit of time between those convictions. And as I noted earlier, this is a joint recommendation from the parties, as previously outlined by the state.
And then are you moving to dismiss count 2?
Yes.
Then count 2 is dismissed.
Thank you.
Attorney Petrowski?
Thank you, Your Honor. With the state's permission, I'm going to deviate just a little bit, actually upward on the recommendation, and ask the court to follow the joint recommendation, but for the revocation and ignition interlock device. I'm going to ask the court to sentence the defendant to the maximum on those. Rather than 33 months, I'm asking for the court to sentence him to 36 months, as long as the state doesn't object that that would be a breach of the plea agreement.
I think that's fine.
Oh, and I wrote down 30 months. Was it 33 or 30?
30 was the recommendation based on the left-sided guidelines that the state had made.
Okay. Attorney Petrowski?
Yep, I'd be deviating upward to 36 months as part of our request for the court to dismiss the refusal. As the state pointed out, the prior offenses are somewhat old. I can tell the court that Mr. Barrett has been at his job for nearly 15 years with Arby's company. He's worked his way up to be general manager of his own location in Verona, Wisconsin. He's been married since 2011. He has a 16-year-old daughter who's in high school. And he served in the United States Marine Corps honorably from 1986 through 1992. As to this incident, I would certainly categorize the offense of OWI, of course, as dangerous in of itself. But as to the facts of this particular offense, backing up in a parking lot and almost backing into another car is something that occurs pretty regularly, regardless of the sobriety of the operator. Driving slowly and weaving within a lane, of course, is enough to draw the attention of law enforcement and other drivers on the road, but it's certainly not the type of dangerous driving that we sometimes see with OWIs. The reason I'm asking the court to deviate upwards to the maximum potential revocation and ignition interlock device is because Mr. Barrett's primary concern isn't the length of revocation or having the ignition interlock device, because he's already had it installed. He had it installed in preparation for the September court hearing. So he has had the ignition interlock device installed for several months now at this point. The concern with the revocation or the refusal is that as it relates to his occupational permit, there are some mandatory wait times when there is a finding of refusal. He's already served out a mandatory wait time for the third offense conviction. At this point, after he's been operating with his occupational permit between that wait time and now. The fact that he's already established the ignition airlock device in his car from that time until now, I think that jeopardizing his job for his inability to commute back and forth to work would be the only effect of enforcing the refusal finding at this point, as he's conceding the maximum potential penalty for the revocation and the ignition interlock device. So under all these circumstances, Your Honor, I think that this is an appropriate penalty. It gives him the maximum revocation, the maximum ignition interlock device, a substantial jail penalty, and substantial fines and costs. I think preventing him from being able to drive to and from work for a second period of time without having an occupational permit would be overkill under these circumstances. Thank you, Your Honor.
Does anybody have the facts for the refusal that you can just give me a brief summary of?
Yes, Your Honor. Essentially, he completed the standard field sobriety tests, declined to blow on the PVT, and then he just didn't answer the questions related to the alcohol report. So he refused to answer. The officer took that as a refusal, requested the warrant, but according to the criminal complaint, he complied with the blood draw. So there was not a physical refusal. He didn't fight the nurses or law enforcement. He just declined to answer the questionnaire.
I'm trying to quickly find the case that it talks about, to see if there's an exact standard that the court should apply with this type of request.
I would just note for the record that if Mr. Barrett was entering a plea to the refusal, we would be recommending the 36 months ignition interlock and driver's license revocation that Attorney Petrowski previously noted.
Okay, I think it's State v. Bentdahl, Bentdahl. In the statute annotations, it says, under Brooks, a circuit court has discretionary authority to dismiss a refusal charge only if the defendant has already pleaded guilty to the underlying OWI or OWI-related charge by the time of his or her refusal hearing, which was timely requested. So I think that is satisfied. Extending Brooks to allow circuit courts the discretionary authority to dismiss refusal charges in cases in which a defendant has pleaded not guilty would contravene the purpose of the section. And then let me look at the case real quick here. It is a Wisconsin Supreme Court case from 2013. Okay, I think it's pretty clear that I can consider the request when the defendant properly requests a refusal hearing, which I think he has done, and he must plead guilty to the underlying OWI or OWI related charge. I guess it does say it is pretty specific in multiple places that the plea does have to be guilty and not no contest.
Your Honor, we would be willing to amend our plea to guilty rather than no contest to satisfy that standard, Your Honor.
Okay, because based on everything that's been presented here, I would grant the dismissal of the refusal citation if he agrees to change his plea to guilty. And you're saying your client is willing to do that?
Yes, Your Honor.
Do you need any further time to talk to him about that?
No, Your Honor.
Mr. Barrett, do you need any further time to talk about changing your plea to guilty?
No, I do not, Your Honor.
Have you been listening to the entire conversation that we've been having?
I have, Your Honor, and I have learned quite a bit, quite honestly.
Okay. And do you want to change your plea to guilty and not no contest anymore?
I will change my plea to guilty.
Okay, and you are freely, voluntarily, intelligently, and knowingly making this decision to plead guilty instead of no contest at this point?
Yes, I am, Your Honor.
Do you need any further time to talk to your lawyer about it?
No, sir, I do not.
Okay. ADA Petrus, do you request any additional questioning?
No, I think that was sufficient. Thank you.
Okay. So I'm going to vacate the no contest plea that you previously entered, and then to the charge of, in count 1, misdemeanor operating while intoxicated, first offense, or operating while intoxicated, third offense. What is your plea?
My plea is guilty, Your Honor.
Okay. I will accept the plea to misdemeanor OWI third now as a guilty plea. I'll find that it's been freely, voluntarily, intelligently, and knowingly made. We've reviewed the elements, the facts, and the rights that he is giving up very sufficiently. Mr. Barrett was tracking on the conversation we were having about the impact of the plea in this case, and he is choosing to change his plea to guilty. I will find him guilty of the offense, order judgment of conviction entered into the record. Count 2 can be dismissed. And then 20 TR 588, the court will dismiss that as well on motion of Attorney Petrowski, noted that the DA's office was not agreeing to that dismissal. And then Attorney Petrowski, if you want to go back to was your argument completed then, Attorney Petrowski?
Yes, Your Honor.
Okay, Mr. Barrett, now is your opportunity to address the court if you choose to do so.
Your Honor, I just want to say that, you know, I'm taking responsibility. I understand what I did. I have gone to lengths to make sure this will not happen again. And I appreciate anything you can do for me.
Thank you. And you did serve in the Marine Corps?
I did, sir, 86 and 92.
1986 to 1992?
Yes, sir.
Did you serve overseas or was it all within the United States?
It was all within the U.S., sir. I was with 2nd Battalion, 5th Marines out of Camp Pendleton for a few years and then down at the Landing Force Training Center in Coronado.
Okay, thank you. And I did consider your Marine Corps service when making the decision on the refusal.
Thank you.
So that was kind of the benefit that I gave you for having that positive characteristic in your life.
Thank you.
When I consider sentencing, I have to consider the protection of the public, the gravity of the offense, the rehabilitative needs of the defendant, character of the defendant, and deterrence of others, then apply the Galleon sentencing factors to those sentencing objectives. The past record is all OWIs, 2 previous OWIs in 2003 and 2008. They are longer. The time differential between your second and third is larger than we normally see. However, each individual OWI is a very significant event that puts the entire community at risk. And it's what parents fear when their children are getting their driver's license and when they're driving around with their kids, that a drunk driver could be randomly on the road. And even though the driver of that vehicle probably wouldn't hurt a soul on purpose, because they're drunk driving, they're driving a vehicle that weighs thousands of pounds, filled with a tank of gas, and it can randomly hit a person, hit an object, and cause injury or damage to somebody. And if you had injured somebody, or worse yet, killed somebody, then we'd be talking about a totally different case, Mr. Barrett, where we'd have a family in the courtroom telling me to put you away for as long as I possibly can. So you're very fortunate that that hasn't happened to you yet. And right now is the time when you have to get a handle on this. And since you're not going to be on probation, you're going to be left to do it yourself. And do you see anybody at the VA?
Well, no, sir, but I will say that I have gone through counseling through the UW system already. And then with the help of family and friends, and as a father with a 16-year-old daughter getting ready to get her license here pretty quick, this has been extremely eye-opening. And believe me, this is not going to happen again.
Because you're a Marine Corps guy. Do you own firearms?
I do not, sir.
Oh, you don't? Okay. Because I was going to say, if the next one is a felony, the next one's a felony, so you lose your firearm rights if you get convicted of an OWI 4th. You lose
Right.
your right to vote until your civil rights are restored, and you're a felon for just because you got another OWI. So, I mean, I have no control over you after today because you won't be on probation. I'm not going to put you on probation. But if I were you, I wouldn't have another drop of alcohol for the rest of my life so that you don't risk getting that 4th offense, okay?
Yes, sir. And that's actually, honestly, it's not going to be a problem. I haven't had one since January 7th.
Okay.
Of
I'm
last
glad that you're very optimistic, but it might be more difficult than you think. You need to have somebody, a counselor there to help guide you through it and give you the tools whenever there's something that could cause you to relapse, a trigger event.
Yes, sir.
That they'll give you the tools to
And-
mentally and emotionally handle it.
And I do have that through UW. My counselor has assured me that anytime I need anything, I can give her a call.
Okay. Then when I consider all of the Galleon factors, Mr. Barrett's prior military service, his employment, the family history that was put on the record, when considered with the nature of the offense, which is always significant with an OWI, like I said, I do think that the joint recommendation, what's effectively a joint recommendation, is appropriate. 110 days jail, that's with Huber and good time, and he can serve it in any county that will authorize him to serve. $1,200 fine for a total of $2,502. 36 months revocation of driver's license and 36 months of the ignition interlock device. An AODA assessment, follow through with all treatment recommendations, and pay the blood draw fee of $46.50. That blood draw fee of $46.50, I do want paid within 30 days so that we get it taken care of. The $2,502 paid within 6 months, or set up a payment plan with the Brown County Clerk of Court's office. So if you get to 6 months and you haven't paid it off, make sure you set up a payment plan. Don't just ignore it.
Yes, sir.
Is there any credit, Attorney Petrowski?
How long did you sit before you bonded
It was,
out? Overnight?
no,
Okay.
No.
Same day.
yeah.
1 day credit, Your Honor.
Does the state object to 1 day credit?
No, that's fine.
Then 1 day credit. Anything additional from the state?
No, thank you, Your Honor.
Attorney Petrowski, if you could review the post-conviction rights of your client, and then is there anything else from you, Attorney Petrowski?
No, thank you, Your Honor.
Okay, then good luck to you, Mr. Barrett, and that's all for today. Thank you.
Thank you, Your Honor.
Thank you.
Oh, we do have the mandatory report because it's an OWI 3rd, Attorney Petrowski.
Yes, by 8 p.m. tonight.
Yeah, so you would have to report by 8 p.m. tonight.
We're prepared for that outcome, Your Honor.
Okay, excellent. Thank you.
Thank
And
you.
that's all. Thank you.
Thank you.
And then Attorney Freilich, you're the last case here today. So whenever you're ready, we can call your case. This is Brown County case numbers 20 CT 617, 20 CT 785. They're both state of Wisconsin versus Corey Richard Oligny Mande. The state is here by Assistant District Attorney Jessica Petrus. Attorney Chris Freilich is here. With him on his video conference feed is Mr. Oligny Mande. The hearing is being done by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Freilich, what is our status here today? Oh, you're muted if you're responding.
Sorry. I can tell you that the state and the defense have talked about this case. Mr. Oligny Mande wishes to enter a no contest plea to operating while intoxicated, second offense. The other case, 20 CT 785, will be dismissed and read in, Your Honor.
And Judge, if I could be heard on that. It's my understanding that on January 7th or around then, the defendant picked up another case. So I don't believe there's currently a global offer. And that is a victim case as well. I think that one is still down in CCA.
Okay. Is that another OWI? Do you know?
The charges in that case are battery, disorderly conduct, and misdemeanor bail jumping.
Okay. Attorney Freilich, I guess, did you want to try to have a global resolution?
No, I want to resolve the OWI case today. The offer that I'm looking at, Your Honor, does not say anything about, hey, if you get another, if you catch another case, then the offer will be revoked. I'm looking at an email from October 16th of 2020.
Yeah. ADA Petrus, I guess the question is if the offer is still valid or not.
I'm trying to, if I could just have a quick second to look at the files.
The other thing is the state's recommending the right side guidelines, so it really doesn't matter. I mean, it's a guideline case.
It doesn't look like the offer was ever put into the standard memo that we usually use. That does include that language that the offer is revoked if additional charges are incurred. I would just note that Attorney Hillman put a note in the file yesterday that indicated the defendant had a new file, so she needed a new global offer. So I believe it was her understanding that the offer would be revoked based on the new law violation, but I understand Attorney Freilich's position too if it wasn't put in that standard memo that we normally use and just sent in an email that wouldn't have been explicitly stated.
Yeah, I did receive an email from the prosecutor at 4:56 p.m. And basically, it says right side guidelines.
What date did you receive it?
October 16th at 4:56 p.m.
Okay. I don't know if an offer is automatically void, if there's a law that says that it's automatically void if there's a reoffense. I don't know the answer to that off the top of my head. I guess it's up to the state if you want to proceed today or not. I guess from Attorney Freilich's perspective, his client can always plead to the charge and with no and argue sentencing.
You know, Your Honor, we're really splitting hairs here. We want to go ahead and enter a plea. The state's going to recommend the right side guidelines, so I don't think they can go over the guidelines. So there's really nothing to argue about.
Well, I don't know the answer whether an offer is automatically terminated because of reoffending.
I don't think it is. Oh, I'm sorry, I didn't mean to interrupt you, Judge. I mean, we typically have the language included in our offer memos, so it's explicit, but again, it doesn't look like this offer in these cases was sent in that typical memo that we use, so that wouldn't have been included.
Well, the question is, does the state go forward on the same offer?
I think we could proceed on the offer between the OWI file and the OAR file.
Okay. Then, did you talk to your client about the video conference appearance, Attorney Freilich?
Yes, Your Honor, he agrees to appear by video.
Okay. Mr. Oligny Mandy, you do have a right to be present in person in the courtroom. Are you willing to waive that right so we can continue to proceed by video conference?
Yes, sir.
And if you need to talk to your lawyer privately, you just mute the feed to talk to him privately. And then Attorney Freilich, it looks like you reviewed the plea form in person with your client?
Yes, I did, Your Honor.
And Mr. Oligny, Mandy, it looked like you did sign the plea form at the end.
Yes.
Does that acknowledge you reviewed the entire form with your lawyer?
What was that?
Does that verify that you reviewed the entire form with your lawyer?
Yes, sir.
If you are not a citizen of the United States of America, you are advised that a plea of guilty or no contest for the offense with which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law. Do you understand that?
Yes.
According to the plea form, you are 28 years old. Is that correct?
Yes, sir.
And you do have a high school diploma or any equivalency?
Yes.
And you do understand English, correct?
Yep. Yes,
According-
sir.
According to the plea form, you are not currently receiving treatment for mental illness or disorder. Is that correct?
Correct.
And you have not had any alcohol, medications, or other drugs in the last 24 hours. Is that correct?
Correct.
The charge in count 1 of the criminal complaint is operating a motor vehicle while under the influence, second offense. That is a misdemeanor with a maximum penalty of 6 months jail or a $1,100 fine or both. You understand that's the maximum penalty?
Yes, sir.
There's also a minimum penalty that's required of 5 days jail and a $350 fine. Do you understand that?
Yes, sir.
Do you understand I don't have to go along with any plea agreement or recommendation, and I can sentence you up to the maximum penalty? Do you understand that?
Yes, sir.
The state is asserting that you have a prior conviction for operating while intoxicated with an offense date on March 17th, 2019, and a conviction date on May 14th, 2019. Do you agree that you have one prior conviction for operating while intoxicated?
Yes.
The elements of this offense are first, that you operated or drove a motor vehicle on a highway, and second, at the time you operated the motor vehicle, you were under the influence of an intoxicant. You understand those are the elements of this offense?
Yes.
And you understand this is a misdemeanor because you have that one prior conviction. Do you understand?
Yes.
Your constitutional rights are the right to a jury trial where all 12 jurors would have to agree that you're either guilty or not guilty. Your right to remain silent, your right to testify and present evidence, your right to subpoena witnesses, your right to confront and cross-examine witnesses who testify in court, and your right to make the state prove that you're guilty beyond a reasonable doubt. You understand you'd be giving up those rights by entering a no contest plea.
Yes, sir.
Are you doing this of your own free will?
Yes, sir.
Has anybody put any pressure on you or forced you to make this plea?
No, sir.
Do you understand if I accept your no contest plea, I will find you guilty of the offense?
Yes.
Attorney Freilich, are you satisfied your client is freely, voluntarily, intelligently, and knowingly making this plea?
I am, Your Honor, yes.
Are you satisfied he understands the elements, the facts, and the rights he is giving up?
Yes, I do.
Mr. Oligny, Mandy, do you have any questions about anything we've talked about today?
No, sir.
Then to the charge in count 1, misdemeanor, operating while under the influence, second offense, what is your plea?
No contest.
I will accept the no contest plea. I'll find that it's been freely, voluntarily, intelligently, and knowingly made. Find that he understands the elements of the crime, the facts support the elements, and he understands the rights that he is giving up by entering the plea. I will find him guilty of the offense and order judgment of conviction entered into the record. And then the state's recommendation, please.
Thank you, Judge. The state, first to clarify, I'm sorry if I missed this. The state is also moving to dismiss and read in 20 CT 785, which I believe just has one count of operating after revocation.
20 CT 785 will be dismissed. Count 2 and 20 CT 617 will be dismissed. And then
Thank
you
you.
may continue.
Thank you. The state is recommending the right-sided guidelines for a 0.134 BAC for OWI second, which includes 30 days jail, a $500 fine plus costs, totaling $1,618, 14 months revocation of driver's license, 14 months imposition of ignition interlock device, AODA, and a blood draw fee in the amount of $26.80. With respect to the facts of this case, on February 15th of 2020, at around 7 a.m., a Brown County Sheriff's Office deputy was dispatched to Van Buren and Catherine Street for a report of a vehicle in the snowbank. He arrived and saw the vehicle, which had its front end in the snowbank, and the driver of the vehicle was sleeping or appeared to be sleeping. The deputy knocked on the window and the driver woke up, and the driver was the defendant. The deputy noted an odor of intoxicants and glassy eyes, and the defendant did admit to drinking a lot. He performed the HGN test, in which the deputy observed 6 out of 6 clues. On the walk and turn, he said he was giving up, and he didn't do the one leg stand test either. He submitted to a PBT, which returned a result of 0.124, and then subsequently consented to the blood draw, which yielded a BAC result of 0.134. He does have a prior record. He is a 2007 juvenile adjudication for first-degree sexual assault of a child under 13, a 2010 conviction for exposed genitals to a child out of Oconto County, in which he was sentenced to prison, a 2011 conviction from Brown County for third-degree sexual assault, in which he was again sentenced to prison, and then the 2019 conviction for OWI first. The state does believe that the right-sided guidelines are appropriate here due to the recency of the OWI first, in addition to the fact that the defendant had crashed into a snowbank when deputies made contact with him. And for those reasons, we do think that the right-sided guidelines are appropriate.
Attorney Perry.
Thank you, Your Honor. Corey Oligny, he's 28 years old. He has a new baby, Matthias, who was born on August 1st of 2020. My client's working with the mother for visitation. Corey went to Southwest High School, then transferred to Oconto Falls High School, where he graduated in 2012. Corey works full-time at Bay Towel. He works a lot of hours over there. He plays semi-professional football for the Brown County Blackjacks and finished his 10th season as a safety and wide receiver. I know on February 15th of 2020, last year, he went out with some friends downtown, left the group, drove his friend home, and then ended up over by Van Buren and Catherine Street. It was slippery, and at 6:59 a.m., he slid into a snowbank. There was no crash. There was no other vehicle. This is a one-way street, and his front end was stuck in the snowbank. The vehicle was running and the shifter was in drive, but the car was not moving. The officer did smell alcohol. My client's eyes were glassy. Corey admitted to drinking at the end field sobriety test, and he was outside and he did some of the other field sobriety tests. He had no hat or gloves on, and it was freezing cold because he just had a small leather jacket on. He did answer questions on the alcohol influence report and was cooperative with the deputies during the entire process. I watched the DVD, and my client was standing out there trying to answer questions and was trying to bundle up inside of his jacket. It was blowing winds, and the prosecutor is right that his PBT was a 0.124 at 7:29 a.m. and then his BAC level was a 0.134 at 8:19 a.m. So there was some time for it to go up. I think that my client realizes that he made some poor choices on this particular date. I think that the right side guidelines are for crashes or aggravated driving. In my opinion, I think it's a mitigated, it's a left side case. You know, it's February, it's slippery, there's snow everywhere in February. We all know that. I think you should consider 20 days in jail with a 13-month revocation of his license and a $450 fine plus court costs for a total of $1,555, 6 points, and the AODA assessment. I think my client's going to definitely need that money to pay for his child, and provide for his child. So I'd ask that you consider going with the left side guidelines. Give him 30 days to report because he's going to have to kind of work that out with the jail with regards to work and all of that for Hubert. Thank you.
Does he have any credit at all?
Did he spend any time? Did he get arrested though? He got released. Yeah, released from the hospital. Yeah, he got released from the hospital, so no credit.
Okay. Mr. Oligny Mandy, now is your opportunity to address the court if you choose to do so.
He's loud enough.
I mean, I was going through a rough patch with my current ex-girlfriend, well, my son's mother at the time. She told me that she was gonna get rid of our child, an abortion, and it hit me harder than I expected. I went out with friends just to be around them. I didn't expect to drink that much as I did. I mean, I made a mistake again. Like I said, I had a lot on my plate at the time with her telling me that she was planning on getting an abortion and stuff like that. So it hit harder to me, I guess, than I thought it would. So I'm looking back at it, it's affected my life so far. So moving forward, I've just got a recent promotion at work. I got a raise at work. I'm entering another season of my semi-pro football team as a captain, a person to look up to in the community as with the football team. It's really all I got. I mean, I apologize for my actions. That's really all I can say.
Thank you. When the court considers sentencing, I have to consider the protection of the public, gravity of the offense, rehabilitative needs of the defendant, the character of the defendant, and deterrence of others. Then apply the Galleon sentencing factors to those sentencing objectives. And I think all of the sentencing objectives are relevant in this case, but protection of the public is always paramount in these drunk driving type cases. And one drunk driving incident puts the entire community at risk, and now this is your second one, and the penalties escalate with each subsequent OWI that you get. So the penalties increase for the third, and then the fourth, it's actually a felony. So you're talking about potentially going to prison on an OWI case, and then after that, and each subsequent one after that, then you're looking at going to prison. So you really need to get a handle on this now if you don't want to go back to the prison system. I hope that's one of your goals in life, to never end up back there, because I know it sounds like you have had prison sentences in the past, and hopefully you have goals in your life that'll be it. Okay. And it sounds like you do have positive characteristics. You're a high school graduate. It sounds like you have employment history, and then you are involved in community activities as well. I mean, that factually in this case, this one in particular, I mean, it's a pretty serious incident, Mr. Oligny Mandy. I mean, you're in a snowbank in this case, fortunately, and maybe it wasn't even your drunk driving that caused you to slide through the road, but if you would have slid through the road in the same incident, hit another vehicle, and seriously injured or killed somebody, we'd be talking about a totally different case, where there'd be a family in here telling me to send you away for prison for a long time because you seriously injured their family member or killed them. So that's what the consequence is sometimes in these drunk driving cases. When you have multiple vehicles colliding into each other that weigh thousands of pounds, even going at a slow miles per hour, it's the human beings inside the car that absorb the force and can be seriously injured even at a low speed collision. And that's really what parents in the community fear. And you probably will too. If this is your first child, you're going to fear drunk drivers being on the road and injuring your child when they're driving around on the vehicle, particularly in the early morning hours like this. So I do think when I analyze all of the Galleon factors in this case, all the positives and the negatives. I do think that the right side guidelines is appropriate for the 0.134 BAC. That's 30 days jail with Huber and good time. No credit, it sounds like. A $500 fine for a total of $1,618. 14 months revocation of driver's license, 14 months of the ignition interlock device, an AODA assessment and follow through with all treatment recommendations, the blood draw fee of $26.80. The $26.80 is due within 30 days. And then the $1,618 is due within 6 months. If you're not able to pay that within 6 months, don't ignore it though. Contact the Brown County Clerk of Court's office to set up a payment plan. And then for a report date to jail, Attorney Freilich within 60 days.
Sure.
Did you pick a date?
Oh, sorry.
Yeah, your client can pick a date within 60 days.
Okay.
Let's see here, 11/60. so, February 25th, March 25th. You want to go sometime in March? What day? 18th? How about March 18th, Your Honor?
Yes, report March 18th.
Okay.
And then ADA Petrus, anything additional?
No, thank you, Judge.
Attorney Freilich, if you could review the post-conviction rights with your clients, then is there anything from your perspective?
Nothing further. Thank you very much.
Okay, then that's all on this case, and that's the last case of the day as well.